Thank you, Your Honor, for the bench warrant and for being sure that Mr. Robertson could be here. I would like to know if he could be in Chapel for the hearing so we can make notes. Thank you, Your Honor. Gretchen Swen, S-W-E-E-N, for Robert Roberson.
Good morning, I'm Donald Salzman on behalf of Mr. Robertson.
Thank you all for being here. You're welcome to be seated, and obviously we're here on the state's motion to have this date set. Of course, the grant motion, responses, as well as a significant number of underlying documents. Say everything you have this morning, in addition to what's being same opportunity to defense, and read everything you all have filed, as well as go back to some written applications and like clerk's file in this case. And I know you all have a request to get a little bit of a record here, and I'm happy to give you that time, but specifically, is there anything that is not included in the response that you're interested in?
Yes, Your Honor. If I may approach. I have an excerpt from 43-141 of Texas Criminal Procedure, which, as Your Honor likely knows, is the only statute that governs the setting of execution dates in Texas. And as you probably are aware, there's nothing in Texas law that requires the court to set a date at any particular time, but there are provisions about when it is disallowed or when it can be withdrawn. So what I have approached the bench with, Your Honor, is that excerpt about when it is appropriate to consider withdrawing an execution date, along with sample entered orders from Bowie, Collin, Baird, Dallas, Harris, Beatty, Henderson, Montgomery, Cameron, El Paso, Grayson County, etc., where it is quite normal to withdraw a date under the circumstances presented here, which is when a habeas applicant files a subsequent writ application. That's often when the date gets withdrawn. So in our view, and as you know from our objection, it is quite unconventional to try to set a date when there is already a habeas application pending before a higher court, and it seems like there's no other legal reason other than, well, there's no legal reason at all to be seeking a date now. There's perhaps a political reason, which really has no place in the courtroom, which is to put pressure on this higher court to hurry up and rule. And obviously, we weighed you down with a bunch of paper, Your Honor, and I apologize for that. But part of the point was to show these are substantive claims for habeas relief that the Court of Criminal Appeals is considering. It's been pending for 5 months now, I believe. So to suggest that, oh, we need to hurry up and set this date now really is contrary to law. It's impractical, because if one were to enter an execution date, we turn around and file a motion to withdraw that date, and we file a motion to stay. And if, of course, we are denied by the CCA, we recognize that's a different circumstance. And at that point, we'd be left to go to the federal court and try, and there would be no state law saying anything about holding off on a date. But right now, it makes no practical sense, and it also, quite frankly, makes no moral sense, as it would trigger all kinds of very stressful deadlines and circumstances. Mr. Robertson is a member of a pilot program in death row for the past 2 years, where he spends hours every day out of his cell unshackled. He was chosen among 12 people to be part of this program. If an execution date is set, however, he will be pulled out of that program, put on death watch, which is 24 hours surveillance. Meanwhile, you have obligations on TDCJ that become much more stressful. You have obligations on the clerk of this court to enter an execution warrant, etc., none of which needs to happen right now as a matter of law or as a matter of fundamental justice.
So
Right, we don't have a motion to modify or withdraw because the circumstance that would allow for that have already happened, which is the filing of the subsequent application. So it's just a motion to set a date when the conditions are really not right.
And I guess, talk to me a little bit about the conditions, because I understand your concern about 7 days and 7 days, or rushing to 7 days. But could this not become a situation if court here does what you're asking me to do, just hold off with arguably no justification of legal authority to just use the 7 day, and when the date is properly been requested, what would keep someone, not saying how to do this by industry, but in a different case from coming in and filing a subsequent application every time the execution date is set, just to have, to prevent any date being set prior to the date being on. And at some point, don't we have to say the date needs to be set? And that will allow the Court of Criminal Appeals to take whatever action they feel is appropriate. And of course, we got people here within minutes by 7 execution date, everybody else is going to know that happened. CCA acted immediately this afternoon and tell me, one, to do a rescindal order, or two, to overrule my decision and say we're going to wait. I mean, why? Don't we have some obligation to balance, let's not rush this, with also let's not let this linger forever?
Your Honor, it's an excellent point, except I'll again point out the convention is that dates aren't requested under these circumstances. This is highly unusual, and therefore there is no practice of the CCA instantly intervening and saying, hold off. It would require a motion, it would require litigation, and we would still then have to come back and ask for it to be withdrawn unless the CCA acted in stay, but they would not act sui sponte, because this doesn't happen like this. And as for your question about good faith filing of subsequent writs, I mean, that's why there's an abuse of the writ statute in 11071. The bar gets higher every time you file a subsequent writ. And it is not something any lawyer does lightly. You have to bring new evidence that wasn't previously available when you last filed. And I'll also point out, in the innocence context, we have proof that, I'll invoke the name of Anthony Graves, if that means anything to Your Honor. He is an exoneree who filed multiple subsequent writs, claimed to be abusing the writ. He had 4 execution dates. He was only given relief by the 5th Circuit. But we now know this is an innocent man. Texas has formally recognized him as an innocent man, exonerated him, given him financial compensation for the 12 years he spent on death row, wrongfully convicted. So these things don't always get sorted out the first time around. So the fact that we have filed another subsequent writ, raising very complex medical issues. I mean, our latest writ, we have a report from the leading bleeding disorder expert in the nation, who is the head of pathology at UTMB, Dr. Michael LaPasada. This is yet more evidence to explain Robert's daughter's condition when she was brought to the hospital, and then what was seen at autopsy and what was not considered. There's been a lot of misinformation about this case, that it's not really a shaken baby case, when in fact there are over 200 references to shaking in the trial transcript, that the case was, the restaurant was obtained using a shaken baby diagnosis, but the medical records are complex. That's the problem with the whole shaken baby phenomenon. It was developed to explain seeming mysteries of infants and young children suddenly collapsing. These are not easy things for courts of law to deal with. So, Your Honor, I'm just saying, I don't think that there is any pattern of death row litigants just filing writ after writ to prevent the setting of a date. I think what is more common is it's very hard to bring a subsequent writ, it's hard to get new evidence, and that this only happens when you have substantial support. And we know the CCA's delay means they're considering something, and we should respect that process.
Is it fair, though, to say that the state's statement of positions really isn't necessarily new evidence, it's more evidence of issues that have been brought up in the subsequent or previous subsequent writs? I mean, how do you have, for example, on the DIC and pneumonia and stuff that
The last time the CCA considered any substantive evidence was January 11th, 2023. And at that point, they were relying on findings from the previous presiding judge that were signed on February 14th, 2022, based on an evidentiary hearing that had happened over a year before that. And in those findings, which were drafted essentially by the state, adopted almost verbatim, there was no acknowledgement that there had been any change in shaken baby syndrome science since 2003, that there was no mention of any new evidence related to cause of death. And we know that the CCA simply adopted those findings. It's a 2-page opinion. Since then, the CCA itself, in Ex parte Rourke, decided in October 2024, they have agreed that shaken baby syndrome has changed so dramatically that they believe it would have been difficult to obtain a conviction relying on the very same causation hypothesis that was used to convict Mr. Robertson. And, Your Honor, it wasn't just the same theory, it was the same expert from the same hospital with virtually identical testimony. And they have not yet looked at this case again from a substantive perspective since they themselves re-looked at shaken baby. We did, Your Honor, and there were 4 dissenters to the denial of that. I think it had a lot to do with the fact that all this was happening literally the day before the execution. The opinion in Rourke came out less than a week before Mr. Robertson was scheduled to be executed. And I think it is hard to imagine there was a serious analysis of the case. I think at that point it was like, we're done. And we know from the CCA's opinion, they didn't look at the substance. They denied it as abuse of the writ, even though we were relying on a case that had just issued. And this became a concern of, quite frankly, a bipartisan group of Texas lawmakers who looked at these 2 cases and had looked at the underlying evidence, and they could not imagine how relief was being denied under Article 11073, which is that changed science law. And, Your Honor, it is difficult to imagine, and it's why, again, in this legislative session, there were bipartisan lawmakers, overwhelming support in the House for an amendment to that law to make it clear, essentially, Mr. Robertson should have gotten relief, that the burden is being raised too high. It's being treated as if it's an actual innocence requirement as opposed to an 11073. And we're still waiting for the CCA, I think, to revisit that, that's part of what the new claim is. It brings to the court that critique by the lawmakers, who, after all, are the ones that pass the law. And so the concern about how it's being interpreted in the courts is a legitimate reason to reconsider, which is brand new since we filed an amendment.
Your Honor, if I may, I had a little trouble hearing, but I believe the opposing counsel mentioned the Horvath case. And in fact, there was no explanation in the majority opinion about why they were denying relief. There was only a concurrence that actually was from a dissenter in Rourke, arguing a case for why Rourke, after a few months, should be overturned. It's very concerning concurrence that has now been challenged in a suggestion to reconsider that I believe was filed within days. And so this issue is before the CCA, and the fundamental argument in that suggestion to reconsider is about this burden problem, where the 11073 burden is being raised so high, nobody seems to ever be able to satisfy it. And the other thing I'll suggest, that you asked why now. I mean, there are nearly 200 people on death row in Texas. There's one pending execution date. There's no reason to be setting a date for Mr. Robertson, who is among the few who has live appeals on a very serious issue of statewide concern, because it has sent the state into some turmoil. The seeming tension between Rourke, decided in October, Mr. Robertson's case, and then this Horvath case, where the facts are different, but there is this problem with how is Article 11073 supposed to be interpreted, and we're talking here, unlike Rourke and Horvath, a death penalty case. We're talking about the most serious thing a government can do, which is ask permission to extinguish a life artificially. And respectfully, the state has not articulated in its motion or before the court today any legal reason this must happen today, why you must take this extraordinary, exceptional measure of setting a date when an appeal is pending.
I agree with you on that. It's hard to find a reason why this has to be done today, and hard to find a reason why it's taking so long to get here. I do think it is worth noting that prior to the execution date passed, there was no action on the state's. I was told that things back in the summer, no action on the case, the state, no action on the case. Legislative session is given an opportunity to proceed. I don't see anybody's focus here, but as I already referenced, there was some hope that members of the legislature might address this specifically. This subsequent writ that was filed, I think, for 5 months. At some point, I think my concern is not awareness of it. It's not prohibited by statute from judging awareness of this. I can 100% agree with you, 100% disagree with you, and I have no ability by law. I can take no action on the subsequent writ until the CCA tells me anything. So I'm not making any decision about the merits of your argument. I'm sympathetic to the fight you seem to be having and the lack of response you seem to be getting. But at the same time, the court has to balance a justice system that doesn't move the unjust, a justice system that never reaches finality, never achieves its purpose, and the citizens of this community have a right to be in it. A verdict was reached in their courts, whatever that verdict is, ultimately the verdict will be followed. It's going to the end. And it appears at this point there is no legal basis for the setting of an execution. We're in a unique situation, a number of writs that have been filed, the fact that we some, if not all, of the issues, always have the opportunity to when you want to define to do so, which I think makes this a little different from circumstances where this is the first, second, third, subsequent writ application runs to number 6. And it doesn't seem that anything is going to be resolved without a date to make votes, and that's unfortunate, but it's a reality of our system sometimes. So given that, the court is going to order that execution be set at time after 6 p.m. on 16 October 2025. Court's going to further order the district clerk to prepare a death warrant. If the funds in this court's order do that serve as well, finally the court will make all necessary findings and additional orders by written order file subsequent to today's hearing. With that, is there anything else from your side?
No, Your Honor, I'll just note that there are people who've been on death row out of appeal for years and years. And I do think it's important to
Sorry, sir. Okay.
Hey, Matt, do you want to say something really quick as a response? I don't know if you want me on there. I mean, I'll just do this really quick.
Yes, ma'am. Sorry for the disrespect.
You hold this in your pocket.
I don't know what I even want to say.
Can I talk to you afterward? Can I talk to you afterward?
Yeah. Can we do it outside?
Okay.